The lady from the Virgin Islands, Jill's back. I'll recognize myself for 5 minutes of questioning. Dr. Humphreys, it is currently against the law to prescribe controlled substances outside the course of a professional medical practice. It's a pretty arcane statute. It's not used all that often, but it strikes me that until you control that group that is uniquely empowered to prescribe controlled substances. And I appreciate the fact that Director Baum thinks it's an education issue. I don't know that many dumb doctors. I don't know that many. I don't think it's an education issue as much as it is a money issue. So how do we capture the attention of those uniquely situated people in our culture who have the authority to write controlled substance prescriptions?
Thank you for that question, Mr. Chairman. I divide doctors up as follows. The biggest group of doctors are good people who do the right thing, and they need to be left alone. The second biggest group are good doctors who do the wrong thing, and they need education and training. There is a third group. It is a small group. It's probably less than 1% of physicians who are not good people, and they do the wrong thing knowingly. And we saw this my time at ONDCP in Florida, a massive concentration of people giving out huge quantities of OxyContin. And I think at that point, they're no different than any other drug trafficker. The fact that they're an MD is irrelevant. They know what they're doing. They're being harmful. And that's why we have law enforcement to go after them. And I'm all for them doing that.
Well, I know we do, and we certainly used to. It was phentermine and fenfluramine back when I was at the DA's office. But DA diversion is not as active, unless you know something I don't know. They're not as active as they once were. So I get that it's hard to go after doctors, and just so the record's clear, my dad's a physician. I actually like doctors, but they are uniquely empowered in our culture. Jerry Connolly can't write a prescription for an antibiotic or a controlled substance. Doctors can, and you can be in this specialty, but write an analgesic prescription. So I'm with you. I appreciate the deference you show to physicians that it's an education, and I do think the overwhelming majority want to do the right thing for the right reasons. But there's a lot of money in this particular realm. And until there are prosecutions for physicians who prescribe outside the course of a professional medical. And what I mean by that, just so nobody thinks I'm getting too complicated, writing a prescription on a cocktail napkin at a bar for someone you just met that you've never done any diagnostic test on, you just happen to take his or her word, I like my chances in front of a jury of that being outside the course of a professional medical practice. So, Mr. Baum, as you write your plan, it'd be great if you could address DEA diversion and whether or not they're being plussed up. I know it's tough to go after doctors. Juries are sympathetic with them, but they're uniquely positioned in our culture, and somehow or another we got to address it. Dr. Humphreys, let me ask you this. You mentioned drug court a couple of times. Do you have a position, or is there research that indicates whether pre-adjudication drug courts or post-adjudication drug courts work better?
I'm not aware of research that proves that point because those populations are really different kinds of people, typically, the people who are given the option early versus later. I do know that both drug courts, as well as other models that have been promulgated, Hope Probation is one that now the federal government supports, 24/7 sobriety on the alcohol side, where you use the court as a mechanism to enforce abstinence with regular checks and treatment backup as needed, all show very good outcomes. We should be doing those much more. By good outcomes, I mean you get the trifecta. The public is safer because the person's held accountable, substance use goes down, and then incarceration goes down.
Well, I want you to help me with something if you can, and I ask this respectfully. As you travel, if you're ever invited to address a group of public defenders or criminal defense attorneys, oftentimes they will refuse the offer of drug court because probation is easier. It is not better for their client, but it's easier. So we've got to kind of reconfigure what is in the best interest of the client. remaining addicted, but just having a shorter period of probation is not in the best interest of the client. And they'll believe you and they won't believe an old prosecutor. So in my remaining time, Director Baum, in case my mom is watching, I want to be really clear. I'm not advocating for the legalization of marijuana. I want to be very, very clear about that. However, I don't understand why it's a Schedule 1. It's certainly not treated as a inherently dangerous substance for which there is no medicinal value. It takes a tractor trailer full of marijuana to even trigger a mandatory minimum under our drug laws. So is there any appetite for researching whether or not it should remain a Schedule 1 drug?
Congressman, the administration doesn't have a position on that, but I'm happy to dialogue with your office. And let me just briefly say that we strongly support research on medical use of marijuana. And if there are obstacles that we see that prevent good research, we want to address those obstacles. Because if there are component elements of marijuana that could be put through the FDA process and turned into medicines that could help people in this country, we want to do that. So we do think there's some potential, and we support research on the subject.
Well, just so everyone's clear, methamphetamine is scheduled what?
I believe it's Scheduled
2. Cocaine is scheduled what?
also 2.
Cocaine base is scheduled what? 2. So it is scheduled lower than marijuana. And again, you can schedule something and still not have it scheduled as a 1. And I would encourage the powers that be, whoever you need to consult with in the administration, to at least explore whether or not it's scheduled correctly without being perceived as advocating for legalization.
Understood.
With that, Mr. Connolly, I will give you a chance to, I'm reluctant to say whatever you want, but I'm going to give you a chance to, to conclude.
I thank my friend, and I actually want to follow up, if I may, on, the point being made here in some ways, Mr. Baum, is if you, not you personally, if the government, federal government, on this subject, marijuana, and how dangerous it is, has no credibility because of the lack of serious empirical work, it threatens our whole drug policy's credibility. And you're seeing this happen on marijuana in the states. They're making decisions. Ms. Norton talked about 8 states, but there are over 25 states that have in some fashion, including my home state of Virginia, liberalized their laws for medical reasons all the way to recreational reasons. I think you'd have to confess to the chairman's point, there was no empirical evidence to justify putting marijuana 50 years ago as a Schedule 1 drug. Who did that empirical evidence?
Sorry, could you repeat that? Who did what? Who made it scheduled?
There was no, I am asserting, and you can feel free to try to contradict, there was in fact no empirical evidence to justify putting marijuana ahead of the drugs the chairman just listed as a Schedule 1 drug 50 years ago. And I would, you brought up the need to have empirical research before we start rushing pell-mell to approve it for medical purposes, and I agree with you. But here's the problem. As I said in my opening statement, only one federal entity, NIDA, controls marijuana for legal purposes for experimentation, testing, and the like, research. And NIDA's mission is all about proving the harms of something. They've a priori determined the outcome of research. Nobody thinks NIDA is an objective, neutral place to go to look at the good, the bad, and the indifferent about marijuana. It doesn't have that credibility. So if we're going to do what you suggest, we need to have a different entity with credibility where we're looking at objective evidence and science. And then we can determine, well, where does marijuana work? Mr. Humphreys made the point that there's a more lethal or stronger, more fortified versions of marijuana coming out that concern us. But we put a lot of people in jail, and we've treated this like it's more dangerous than cocaine and the other substances the chairman's, and it's had huge consequences based on very little scientific evidence. I'm not arguing for the legalization either. I agree with my friend from South Carolina. I'm not going there. But neither can I justify the current policy of treating it as the world's most dangerous drug with its classification. You can feel free to respond, and I'm done.
Congressman, I understand the point that you're making. I would love to go with you in your district to talk to police chiefs and sheriffs. I think in reality on the street, police, sheriffs, they don't treat marijuana the way they treat heroin and fentanyl. So I think in practice, there is a prioritization of the most deadly drug threats.
I actually think that's his point, is that law enforcement doesn't, our sentencing scheme does not. Methamphetamine and marijuana are not treated the same from a sentencing standpoint, but yet marijuana is considered to be inherently dangerous with no medicinal value, therefore a Schedule 1. And it would just be helpful, again, to Mr. Connolly's point, for us to have some consistency, or at least be able to explain why certain drugs are Scheduled 1 and others are not. And we can save that for another day. And again, that's coming from two people that are not advocating for the legalization, just for some common sense in how it's scheduled. On behalf of all the members, I want to thank all of our witnesses for your expertise. Mr. and Mrs. Flattery, in your case, your very tragically earned expertise